Welcome to Equity Today, your trusted legal newsroom. In this special report, we explore two important equitable remedies, specific performance and injunction, through 4 Malaysian cases decided between 2022 and 2025. Let's begin our report with the first major topic, specific performance. This remedy is often applied when damages are not enough to deliver justice. To start us off, we go to our first legal analyst, AISHAH.
Thank you, moderator. The case of Rumaya Properties against the Sierra Development concerned 18 medium-cost Vista Damansara units purchased by the plaintiff. Although full payment was paid, the developer abandoned the project and the land was later used to construct a luxury condominium known as Boulevard Residence. The plaintiff sought specific performance or alternatively damages reflecting the high-end value of Boulevard Residence, and the central issue was whether damages should follow the value of the luxury units or remain tied to the original medium-cost unit that formed the subject matter of the contract. The courts applied Johnson and Agnew principle. Damages must place the innocent party in a position where they would have been had the contract been performed, not in a position of extraordinary gain. Awarding Boulevard Residence value would have created a 5-fold windfall and amounted to unjust enrichment. The Court of Appeal and Federal Court both held that damages must reflect original Vista Damansara units, as the luxury development was an entirely different subject matter. The court also rejected the reliance on a 2011 consent order, as that order was premised on hypothetical possibility of specific performance, a possibility that later ruled by superior courts. The correct valuation date was fixed at 11 March 2008, the date the plaintiff effectively lost their contractual rights when the land was transferred. Claims for LAD and rental losses were also rejected because the project never existed. In conclusion, the court upheld damages award based solely on the value of medium-cost units, preserving the equitable principle that compensation cannot operate as a windfall.
Thank you, AISHAH, for that clear and insightful breakdown of the case. Now, we move on to our second analyst, SHAQEER, who will continue our discussion on specific performance with another important Malaysian decision. SHAQEER, the floor is yours.
Thank you, moderator. This case centers on commercial property sales involving a letter of offer marked subject to contract. The purchaser, acting through a disclosed principle, paid an earnest deposit and negotiated all terms. By July 2023, all agreements were settled and the purchaser was ready to pay the remaining deposit when the respondent abruptly withdrew, citing a change in business strategy. The applicant sought for specific performance. The court first affirmed jurisdiction under Section 23, subsection 1 of the Court Judicature Act, relying on the Unified High Court Principle under Article 121, Clause 1. The court then held that the applicant, as disclosed principle, had privity and locus standi to enforce the agreement. The key issue was whether a binding contract exists despite the subject to contract clause. The court referred to authorities such as Air Hitam, Tin Dragging, Charles Grenier and Cipta Shermat, holding that such clause do not prevent contract formation when parties demonstrate a clear intention to be bound. Here, the parties engaged in extensive negotiation, completed due diligence, agreed on terms and paid deposit, and even signed the draft agreement. There were unequivocal acts of performance. Despite responding last-minute withdrawal did not negate the existence of a concluded contract. Specific performance was granted because, first, the property was immovable, invoking the presumption that damages are inadequate. The applicant showed continuous readiness and willingness. And third, commercial certainty requires parties to be held their bargains. And which is fourth, financial hardship or change business plan do not constitute valid defences for them. The court therefore ordered specific performance pursuant to Section 11, Section 20, 21 of the Specific Relief Act 1950.
Thank you, SHAQEER, for that well-explained analysis. A very insightful point on how the court weighed the adequacy of damages and contractual obligation. Now, let's continue with our next segment. We move to our third analyst, Valerie, followed by our final analyst HAZIQ, who will take us into the realm of injunction.
Thank you, moderator. This case involves both prohibitory and mandatory injunction arising from extensive earthworks on Class 3 and Class 4 slope near Genting Highlands. The defendant's action, including cutting the slope toe, destabilized the terrain and create a real risk of catastrophic landslides, threatening hotels' infrastructure and human lives. The plaintiff sought to restrain the work and compelled to restoration. The court first considered whether there were serious issues to be tried, applying the test from American Dynamite and Kit Gerald. The plaintiffs raised both bona fide issues regarding planning permissions, legality of earthworks, and conflicting geotechnical report. Next, the court examined whether damages were an adequate remedy. Given the imminent risk of slope failure, potential loss of life, and irreversible environmental harm, monetary compensation was clearly inadequate. On the balance of convenience, the public safety significantly outweighed the defendant's commercial losses. The defendant also lacked of candor, failing to disclose crucial borehole information and displaying delays in remedial work, which is a factor that weakened their position. The threshold for a mandatory injunction is extremely high, but an expert evidence showed that the restoring that the slope toe was necessary to prevent disaster. The court therefore ordered restoration work and, due to the exceptional circumstances, dispensed with the usual undertaking as to damages. This case demonstrates the court's willingness to act decisively where human safety and land stability are at stake. Equity intervenes most strongly where the public interest is endangered. And thank you. So now I will pass the floor to my next partner to talk about the case. The threshold for a mandatory injunction is extremely high, but an expert evidence showed that the restoring that the slope toe was necessary to prevent disaster. The court therefore ordered restoration work and, due to the exceptional circumstances, dispensed with the usual undertaking as to damages. This case demonstrates the court's willingness to act decisively where human safety and land stability are at stake. Equity intervenes most strongly where the public interest is endangered. And thank you. So now I will pass the floor to my next partner to talk about the case.
This case concerns a Mareva injunction, which is an order freezing a defendant's asset to prevent disposition pending judgment. SHIM obtained an ex parte Mareva injunction freezing up to RM30 million ringgit of Cedric's asset. After both parties were heard, the High Court affirmed it. On appeal, Cedric raised several objections, beginning with the procedural challenge. The ex parte affidavit had been attested by a Justice of Peace. So the Court of Appeal clarified that the Justice of Peace is not authorized to attest affidavits under Section 11 of Courts of Judicature Act. However, these defects were ultimately irrelevant because the ex parte injunction automatically lapsed after 21 days, and subsequent inter partes application was supported by proper affidavits. So this issue was therefore academic. On the merits, the Court of Appeal upheld the injunction based on the classic Mareva requirements. First is a good arguable case where SHIM had already obtained judgment on liability. Second, assets within jurisdiction are supported by affidavit evidence. Lastly, real risk of disposition where Cedric secretly diverted joint venture businesses, attempted to sell major shareholdings, and displayed dishonest conduct. The 30 million ringgit limit was not oppressive because it reflected evidence of a potential 30 million ringgit share sale. However, to avoid an overly broad burden, the court limited asset disclosure to unencumbered assets up to that amount. The court's decision reinforces that Mareva injunction are extraordinary but necessary tools. Courts must protect judgment creditors while ensuring the order remains proportionate and not punitive.
As we have seen throughout today's coverage, equitable remedies like specific performance and injunction continue to play a critical role in ensuring fairness when legal rights alone are not enough. What stood out to me is how the courts today increasingly emphasize clarity, certainty, and balance of convenience before granting such remedies. These cases from 2022 to 2025 clearly shows that equity remains flexible but never automatic. Every remedy must be justified based on the facts. From my own observation, the courts are consistent. Whenever damages cannot properly compensate, equity steps in, and when harm is imminent, the injunction protects the status quo. This deeper understanding helps us appreciate why equitable remedies still matter in modern Malaysian litigation. Now that we have explored our 4 cases, let's deepen our understanding with some academic perspective. We will look at one article for specific performance and one for injunction to see how Malaysian legal scholars support the principle applied by the courts. First, Nur Asia Muhammad and Sharifah Zubaidah in their 2023 study explain how Malaysian courts approach specific performance. They highlight that land is considered unique and damages may not fully compensate the plaintiff. This supports the decision in our specific performance cases, Rumaya Properties and RHB Trustees, where the courts consider whether monetary compensation alone was sufficient or if enforcing the contract through specific performance was necessary. Essentially, the article confirms why court grant equitable relief to ensure fairness and uphold contractual obligation. Next, Zuraida Ali's 2022 article discusses the Mariba injunction, a preventive relief designed to stop defendants from dissipating assets before trial. While our cases, Genting Highlands and Cedric Wong, did not involve asset freezing, the underlying principle is the same. Equity steps in to prevent harm, protect status quo, and safeguard the plaintiff's interest until the court can make a final judgment. This illustrates how Malaysian courts apply equitable remedies to balance fairness and prevent irreparable harm. Both articles provide strong academic support for the reasoning behind the court's decisions in our cases. With these insights, we can now hear the group's comment on each case and see how these principles apply in practice.
I learned that specific performance is strongly favoured for development agreements because land is unique and damages rarely provide fair compensation. The Rumaya case showed me the importance of good conduct and readiness to perform.
So the RHB case taught me that financial hardship is not a valid excuse to escape contract duties. Contracts involving land are taken very seriously, and court will enforce specific performance when the SPA is clear.
My comment to this case is the Genting case has helped me to understand how crucial it is to prove irreparable harm because injunction requires solid factual evidence and the court will only intervene when the balance of convenience strongly support the applicant.
From the Cedric Wong case, I learned how interlocutory injunction act as quick protection. Courts use them to prevent injustice while waiting for the full trial, especially when rights might be permanently affected.
And that concludes our special legal insights report for today. We have analysed 4 recent cases, examined academic viewpoints, and highlighted the principle guiding equitable remedies in Malaysia. On behalf of the entire team, thank you for joining us in this investigative legal breakdown. I'm FAIQ, your legal trusted newsroom. Stay informed, stay analytical, and we'll meet again next in Equitable Today.